All right, let's tackle another one. Put yourself on the exam, and if this is a bar exam, the first thing you want to do is try to situate yourself in the right subject. When I turn the page on this and see this hypothetical with all the numbered points in time, my eye immediately sees Paul called, Paul called, Paul called, Empire offered into evidence, Empire asked done, on cross. So I'm pretty sure this is a straightforward evidence hypothetical. That means it's going to be an incredible racehorse. And I have to tell you, I'm a slow writer. So I have trouble finishing evidence hypotheticals in the time given. This is a 1-hour essay, and it looks like we have 5 calls. So I'm going to need a good strategy. I'll have more to say about that probably in the next issue spotting exercise, but hopefully you've already watched the video I posted yesterday on an essay strategy for evidence hypotheticals. All right, what do we have here? Take a look at the bottom of the page, and it says, assume that all appropriate objections were made. Was the evidence in items 1, 2, and 3 properly admitted? You don't ever want to lose track of the fact that you have to answer that question in your analysis of those items. You have to come down to the conclusion about whether it was properly admitted or not. And were the objections in 4 and 5 properly sustained? Okay, 5 calls. First 3. The end of our analysis has to conclude whether the evidence should have been admitted or not. The last 2 calls, we have to say whether the objection should have been sustained. All right, let's go up to the facts. A car driven by Dunn collided with Empire Trucking Company's truck driven by Kemper. In evidence hypotheticals, you have to set the scene because the rules change depending on whether it's civil or criminal and where in the case you are. This one is a civil case, and it goes on to say that Kemper died at the scene. They're telling us that Kemper is an unavailable witness. I'm going to need that later on. Dunn and Dunn's passenger, Paul, were seriously injured. Paul sued Empire for personal injuries, and there it is. It's a civil case. We have at least one unavailable witness. Paul attempted to serve Siegel, an Empire mechanic who was on duty on the day of the collision, with a subpoena to appear at the trial, but the process server could not locate Siegel. 2 important things about that. Empire is who is being sued. Siegel is an agent of Empire. And I want to keep that context in mind. If we can't serve him, can't find him to serve him, then he too is an unavailable witness. A lot of facts packed into that very brief introductory paragraph. And I'm going to be making notes about that in the margins. Siegel is an agent of the defendant, and he's unavailable. Okay, call 1. Paul called the investigating police officer, Oliver, who testified that he talked to Witt at the scene a half hour after the collision. That 1/2 hour is going to be important, or they wouldn't have given it to us. That's a half hour after the startling or exciting event. Oliver wrote down Witt's statement and attached it to his report. Well, that statement is an out-of-court statement. Oliver testified that Witt told him that he ran over to the scene from the curb and spoke to the driver of the car, Dunn, who told Witt, "I'm not going to make it, and I want you to know the truth. The truck ran a red light." All right, what have we got here? This is a really heavy call, because what we've got here is Oliver on the stand saying, "Witt said to me that the driver, Dunn, told me." So Witt said that Dunn said. This is double hearsay. What Dunn said to Witt is level 1 of the double hearsay. What Witt said to Oliver is level 2 of the double hearsay. This is really, really classic double hearsay. And I think you've heard Dr. Sacuzzo say that the problem with double hearsay is that often people don't see it at all, and other times we have people who just raise double hearsay all the time because they're not sure what it is and they don't want to miss it. You need to be able to identify it and know that you've got it. So it's essentially A said that B said. A said out of court that B said out of court, and that's what we've got here. So now, in order for this testimony to come in, we're going to have to find a way out of the hearsay rule for level 1 and for level 2. But before we do that, we have to cover logical relevance and legal relevance, because this is the first call. So do both. Logical relevance. To be admissible, all evidence must be logically relevant, which in the federal system means it has a tendency to make the existence of any fact of consequence more or less probable. Dunn's statement that the truck ran the red light is relevant to prove that Kemper, the truck driver, was negligent. Okay, that's pretty straightforward. Legal relevance. Cover it and analyze it on the first call. It's generally not a big issue, but you need to cover it at least once. And of course, if it is an issue, you need to cover it on that piece of evidence as well. And it would be good if you had noted double hearsay or totem pole hearsay or whatever it is your law professor called it. And then under that, subhead noted the levels of hearsay. Now, if you have time, for each level, you should try more than one exclusion, exception. Look for more than one. Look at level 1 here, Dunn told Witt. Is this a dying declaration? It is a statement made under the belief of impending death, but the problem is the elements for dying declaration. The statement has to be made while the declarant believed death was imminent. It has to be concerning the cause or circumstances of impending death, offered in a prosecution for homicide or in a civil case. All of that works, but the fourth element is the witness is unavailable. Dunn is not unavailable, so that one won't work. What else can we think about? How about excited utterance? A statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. That one would work. So, Dunn's statement qualifies as an excited utterance. It's an exception to hearsay. The evidence of that statement would come in. The problem is it's contained within double hearsay. So we have to find a way to get level 2 in. What about level 2? Witt told Oliver. It's not going to be an excited utterance because of that 1/2 hour time gap. This is a half hour after the accident. It's hard to call that an excited utterance. Is it a present sense impression? Well, that's a statement describing or explaining an event while perceiving it or immediately thereafter. Again, the half hour is a problem. I don't see a way to get level 2 in what Witt told Officer Oliver. It's not a business record either because it's in anticipation of litigation. It's not a reliable exception to the hearsay rule. So my conclusion for this one is going to be that the evidence was not properly admitted. What about call 2? Call 2 says, Paul called a court reporter who properly authenticated the trial transcript of Siegel's testimony in People v. Dunn, a reckless homicide case relating to the same incident, in which Siegel testified that on the morning of the incident he warned Kemper that the brakes on the truck were defective, but Kemper drove the truck anyway. The transcript was admitted into evidence. Okay, what's the logical relevance here? Well, if Dunn was warned that the brakes were defective and he drove it anyway, doesn't that go to help prove that he was negligent? So I see logical relevance here. Is it admissible? It's an out-of-court statement contained in a transcript. The transcript has been properly authenticated and is the best evidence. Is it hearsay? Is it being offered for its truth? Is it being offered to show that Kemper was warned that the brakes were defective? If so, then we have to find a way out of the hearsay exclusion. The most obvious one that I think about, because of the wording here, is prior testimony. The problem with that is that when you look at the elements, one of them is that it has to be offered against somebody who was a party or privy with a party. That case was People v. Dunn. This is being offered against Kemper, so that won't work. What about statement by a party's agent? Take a look at the elements and you'll see that it works. He was an agent of Empire. He was talking about brakes, which is within the scope of his duty. He was on duty during that time. So that one will work as an exemption to the hearsay rule. So it can be admitted for its truth. But even if it couldn't be, look at effect on the listener. Couldn't it be admitted to show that Kemper had notice? So I think that this statement is admissible for its truth as a statement by a party's agent, and it was properly admitted, but it could have been admitted based on the effect on the listener as well. So this one seems much simpler than the first call. This one is hearsay, but not double hearsay. What about call 3? Paul called Dunn, who testified that she had a green light and was driving below the speed limit when defendant's truck struck her car. This is logically relevant to show who was negligent, that she wasn't, more likely Kemper was. So she's a witness, she's competent to testify. What she's doing is giving lay witness testimony. Is this admissible? Yeah, because it's considered to be within the experience of the lay witness. It doesn't require expert testimony. It's about driving speed. So it's proper to admit it. This is the simplest call so far. This one would take me a lot less time than the prior ones. What about call 4? And now we're into the area where we're supposed to answer the question of whether the objections were properly sustained. Call 4 says, Empire offered into evidence a properly authenticated copy of the conviction of Dunn for reckless homicide based on this incident. Paul's objections to this offer were sustained. Okay, what could the objections have been about? Well, you could question logical relevance, but that won't work because it's relevant to show Dunn was the one at fault. That would exonerate Empire. What about legal relevance? Yeah, it's prejudicial, but it's highly probative of the fact that Dunn was at fault. So it won't be excluded on grounds of legal relevance. What about character evidence? Can we say that it should not have been admitted because it was improper character evidence? Well, the conviction doesn't relate to a past act, but it pertains to the conduct at issue in Paul v. Empire, so it is not character evidence. What about hearsay? The copy is an out-of-court statement. It's being offered for its truth. It's hearsay without an exception, and so it should be inadmissible, right? What about impeachment? Extrinsic evidence of a conviction of a crime is non-hearsay if it's offered for impeachment purposes. So this is a felony not involving dishonesty, and a witness other than the accused is on the stand. So the probative value of the evidence cannot be substantially outweighed by the danger of unfair prejudice. This statement is highly probative of the fact that Dunn was at fault, and it's not going to be excluded on grounds of prejudice. That conviction impeaches Dunn's implicit claim that she was driving safely, so it's admissible as proper impeachment. And now call 5. Empire asked Dunn on cross-exam, "Isn't it true your insurance carrier reached a settlement with Paul, and as part of that written agreement, you agreed to testify on Paul's behalf today?" Paul's objections to this question were sustained. Okay, let's talk about the objections. How about leading question? That's one that suggests an answer, and this one does, but the problem is that leading questions are proper on cross, so that leading question is okay. What about an objection based on the policy exclusion, settlement offer? Well, they're inadmissible to prove liability, but they can be used to show bias, and this one is being offered to show bias. So it's proper for that purpose. What about an objection based on this being a compound question? It contains more than one question. Empire is asking 2 questions, so we can object on that basis. That statement is objectionable because it's compound, and so that objection would be properly sustained. Those are the 3 that are most obvious to me, but you may think of others for this call. Look back at what we've found here, though, and what we're going to have to answer in 45 minutes once we've issue spotted this thing. We have a call that involves double hearsay, and I need to find multiple ways out for each level if I can. We have another call that is more straightforward hearsay. The 3rd call is very short. The 4th call is not. It has multiple issues, as does the 5th call. This is really hard to time. I know that call 3 is the shortest one, and I suspect that it's going to take me longest to do the 1st call. But calls 4 and 5 are going to take me considerable time as well. This one just is difficult to organize and time and finish on time. Most of us need a lot more practice on evidence essays than on most of the other subjects because they're so rushed, so packed with issues. I will try to issue spot another one of these for you within the next few days. And I keep saying it, but it's worth saying it would really help me out if you would share this video with anyone you think would be benefited by it. And if you would subscribe to our channel and like the video. We need to get the word out, and I need to know that this is worthwhile to do, that it's of value to you, and that it's helpful to you.